Comment in the, let me know in the chat if you can hear me now. There we go. All right. All right, guys, we got just a few minutes to go here before we do the oral arguments here. Thank you so much for joining us today. Sorry about the audio issues, but to recap here, we're going to be listening to the audio of the court case today. We will right straight from the Virginia State Supreme Court site. This is getting ready to go. Thank you all so much for joining us here. Then this is very important to all of us. This issue here to be represented by someone who not only shares your interests, but also is a fair representation of all of us here in Virginia, no matter where you live. If you're in the Northern Virginia, Richmond metro area, Hampton Roads, that you have someone who represents your interests the same way someone who would in Tazewell County, in Wise County, in Rockingham County, in Frederick County, in Goochland County, Culpeper County, the rural areas as well. It is very important that we are all represented fairly, and that is why you are been so tuned into all this, and I certainly appreciate your support. If you voted on this, if you went out April 21st to vote, please let me know how you voted. Drop yes or no in the chat. Let me know that you went out there and voted and what you voted for on this one. Oral arguments are set to begin here very quickly. I'm going to switch over to the Virginia State Supreme Court site, and we will get going.
Oyez, oyez, oyez. Silence is commanded on pain of imprisonment while the Honorable Justices of the Supreme Court of Virginia are sitting. All persons having business with this court will draw near and give their attention. Any having pleas to enter or suits to prosecute, let them come forward and they shall be heard. God save the Commonwealth and this honorable court.
You may be seated. Good morning and welcome to the special session of the Virginia Supreme Court. I am Chief Justice Cleo Powell. All of the justices of the court are sitting. Please call the case.
Don Scott, in his official capacity as Speaker of the Virginia House of Delegates et al., against Ryan T. McDougall, Virginia State Senator and Legislative Commissioner for the Virginia Redistricting Commission et al. Richard F. Hopkins III, Matthew A. Seligman, John E. Lichtenstein, Tillman J. Breckenridge, Appellants Counsel, Michael A. Thomas, Thomas R. McCarthy, Connor D. Woodfin, Appellees Counsel.
Madam Chief Justice, members of the panel, may it please the court. I am Richard Hawkins of the Hawkins Law Firm. It is my privilege this morning to be here on behalf of the appellants, Speaker Scott, Leader Surville, and President Lucas. And it is also my privilege this morning to introduce my co-counsel, Matthew Seligman, a member in good standing of the California Bar, and one who has been admitted pro hoc vice before this court. Mr. Seligman will be handling the oral argument, and I turn it over to him now. Thank you.
Thank you, counsel.
Madam Chief Justice, and may it please the court, I'd like to reserve 3 minutes of rebuttal time. Also, I've been informed by counsel for the legislative clerks that he will be yielding his 5 minutes of time to me.
Okay, so that gives you how much time, Mr.
20 minutes total, Your Honor.
Thank you.
Madam Chief Justice, and may it please the court. Last week, the people of the Commonwealth approved an amendment to the Virginia Constitution. That approval was the final step in a clear and comprehensive process laid out in Article 12 of the Constitution. The General Assembly and the people complied with every step of that process. First, the General Assembly approved the proposed amendment for a first time in October of last year while sitting in special session. Second, the General Assembly referred the proposed amendment to its session after the next general election. That next general election took place on November 4th, 2025. The General Assembly then passed the proposed constitutional amendment a second time in January of 2026 on January 14th. Finally, the people approved the proposed constitutional amendment last week on Tuesday, April 21st. The General Assembly and the people thus complied strictly with every step that the Constitution requires. That is all that Article 12 requires. As a result, The proposed constitutional amendment has been ratified and is now part of the Virginia Constitution. The Circuit Court attempted to interfere with that democratic process by halting it. This court properly put a stop to that. The challengers here now try to overturn the results of that democratic process. This court should not countenance that either.
I don't understand that as a legal argument, given that you asked us to invoke our, ironically enough, named Scott decision from over 100 years ago that specifically says you don't deal with any potential procedural irregularities before the people have voted. So saying that the people have voted yes after having said you don't even look as to whether there's a procedural irregularity and after it's voted doesn't add anything to the equation, does it?
No, and to be perfectly clear, we're not arguing that this court lacks jurisdiction to review whether the constitutional requirements of Article 12 have been complied with. It does. Instead, I'm saying that on the merits, this court should not accept the challenger's arguments.
But the fact that there's a yes vote doesn't tell us anything about those merits.
No, it does not. So now on to the merits of those arguments. Those arguments lack merit. So the first argument the challengers offer is that the General Assembly didn't properly pass the proposed amendment at its special session in October of 2025. That is error. Now, the challengers here have abandoned the principal basis that the Circuit Court relied on. That principal basis was whether the General Assembly complied with its own rules of procedure. And the challengers are right to abandon that argument. The reason, yes.
You don't disagree that the General Assembly didn't follow the terms of the resolution for expanding. The argument is, as a legal matter under Article 4, Section 7, it's irrelevant that they didn't follow that.
And that principle is firmly rooted in law, in American law, and in this court's cases.
And that's a yes.
That is a yes. But to be precise, so first of all, there are 2 points here. One about judicial power and the second about compliance with legislative rules. First, about judicial power. This court does not have the power to enforce alleged violations of legislative rules. That principle has been established by the United States Supreme Court. It's been established by this court and state courts around the country. That's the point about judicial power.
Essentially,
Now,
what they're
I think
saying
that's a
here
compelling
is that the
argument
people
on,
got a chance to vote
how
on
the
it. And
legislature
we should
by majority
we
vote
should
sets
honor
up
that
its own
vote
rules.
and
The more
move forward
tricky
no matter
and,
how we got
in
here.
my
It doesn't
mind,
really matter that
unprecedented,
when the first time we voted to
aspect
do
of
this
that
back in
question
October, early
is
voting for the
the
November
idea of a
4th,
sort of perpetual
2025 election
special
was already
session
underway.
when
So
the
it doesn't really matter if the
Constitution
people who
envisions
cast
a
their vote
citizen
early didn't even
legislature
know
that's
we were going to do
part-time,
this,
that
didn't even
meets
get a
at
chance to
prescribed
weigh in
time
on this.
periods,
Doesn't really matter.
and we're
We
writing on a
decided,
blank canvas.
later
on that
into the
question,
process that
and
we're going to do it,
so
and that's
to me
all that
that was the
matters.
argument that had more
To everybody else, forget them, be damned, whatever. It
layers
doesn't
to
really
it
matter
than the one
because
you were
what
just
we decide
immediately
to do
addressing.
today is the only thing
Well,
that matters.
I think
That's
the text
their
ultimately answers
argument
this
here.
question. It's true
In
that this
addition
court has
to,
never
well, the
addressed
people
it,
voted, so
but I
we
think
have
the
to now
text of the
honor that.
Constitution answers that question. So Section 6 itself says exactly what the challengers wish that it said about special sessions. It does say it about reconvened sessions. It specifically limits the business to be conducted at special sessions to, yes, Your Honor?
But other than following up on Justice McCullough's question, other than constitutional silence, what is your authority that a special session survives the convening of the next general session? Because from the 1971 debates, it was, do we let them meet once every 2 years for 90 days to annual sessions of 60 and 45 days with potential to be expanded by 2/3 vote? Clear implication, we don't want a legislature that sits year round. Your interpretation of the special session would allow them to sit in continuous session for the better part of 2 years.
I don't think that's quite right, and I think the distinction is important. So what the Constitution permits, well, so what it requires is a general session sitting for a limited period of time. Then it authorizes the General Assembly, by applying to the governor with a 2/3 vote, or the governor on his own motion, to convene a special session. Now, that political process that leads to the convening of a special session is different than a general session, and that's what makes it special. So what the 1971 Constitution did is it created a process for political accountability. And that process for political accountability means that the members of the General Assembly and the governor will have to answer for the fact that they convened a special session, which they will in the general election.
But my question is a little more specific than that. Special session definitionally is something that happens outside of a general session. if you've been in special session and we get around to another general session, why doesn't that, by its very nature, the term special and general, why doesn't the general end the special? What authority do you have for that proposition other than constitutional silence?
Well, I think the constitutional silence is telling, and that constitutional silence exists not only in contrast to other sentences in the very same section of the Constitution, but also in contrast to every single, and I repeat, every single other state's constitution that the challengers rely on here. So beyond that, I think the purposes of the power to convene a special session illuminate that silence. The purpose is to be able to deal with exigencies that arise that are unexpected and outside of the regular course
Would
of
a
business.
special session convened in 1929, if they forgot to adjourn sine die, still be in session?
No, Your Honor. And I think there's an important distinction here. And this is reflected both in the Virginia legislature and also in Congress and other states' legislatures. So any open sessions at the end of the term of office of the members of the General Assembly here or Congress, it automatically terminates. Now, the practice has been mixed here about whether the General Assembly adjourns and die expressly or just lets the sessions expire with the expiration of term of office. And that reflects the practice both in Congress and in other states as well.
Turning to Article 12, Section 1 specifically.
Yes.
Do you agree that the word next in modifying next general election for the House of Delegates means that if the election has started, that's not the one. You have to go to the next one. Your disagreement with the other side is when the election starts.
My disagreement with the other side is the definition of the word election in 5 separate provisions of the Constitution.
If a constitutional amendment is passed by the General Assembly at 5 p.m. on the first Tuesday after the first Monday in November, that can't be the election to which it refers.
So I think that's a much harder case that's not presented here. I think it's probably that wouldn't be valid, but again, that's a very different case here.
You would say doing it on election day itself, anytime before the polls closed, might be valid?
I think probably not. The point I'm just trying to make here is that that's not the case that we have here. The case that we have here is the General Assembly passed the proposed amendment before the election, where the term election is defined in the Constitution by 5 separate provisions as a single day that takes place in November. So Article 2, Section 6 defines the election as the November general election. That is an election that takes place in November, not over a 3-month period that begins in September.
But does it? Because the phrase in Article 12, Section 1 is next general election. And Article 2, Section 6, that's when the members of the House shall be elected. It's not the same phrase. It's not the same word. It's not even the same type of speech. One is a noun, one is a verb. What is inconsistent with interpreting election as describing the process and saying shall be elected is by definition the termination of that process by which the members are elected. And in fact, the verb is passive. Somebody else has to do something for them to be elected. That is, the voters have to vote.
So 2 answers to that, Your Honor. The first textual and the second structural. The textual answer is that we have other provisions of the Constitution that answer directly this point. So Article 7, Section 4 says regular elections for such officers, this is local and county officers, regular elections for such officers shall be held on Tuesday after the first Monday in November. And so that answers exactly the grammatical point, which is that we have a coherent structure across multiple provisions of the Constitution, that the election takes place on a single day, that takes place in November, assuming it's a general election. And there can be early voting that participates early in that election that takes place on a single day.
So your position requires us to interpret election in such a manner that literally every single vote that is cast for whatever the office is cast before the election even begins.
Yes, Your Honor, and that's consistent both with the way the federal government has consistently interpreted this, the federal courts, and sister states. A contrary interpretation would make Virginia a sole outlier.
We have consistently held that constitutional provision should be interpreted unless there is a specific legal definition provided in the provision, as the way the people who would have ratified it would. Do you think it is at all anomalous to tell somebody that when they went and voted for a member of the House of Delegates, up or down, irrevocably cast their vote, that they were not actively participating in the election when they cast their ballot?
Well, two responses, Your Honor. Again, going back to the text as you referenced, there is a specific explicit definition.
Not in Article 12, Section 1, there isn't.
But as this court has repeatedly held, it interprets the Constitution as a whole. And so the words that appear in one provision should be interpreted in a manner that is consistent and harmonious with the word.
If they're the same words, but they're not.
Well, so it's the word elected. And then again, in Article 7, Section 4, it is the word election. But moving on to your other concern, I understand. I understand the concern that someone who casts their ballot before something happened might be upset or regret that. And that is a problem that is endemic to early voting. That is a problem
which you guys support, which you guys put 45 days of early voting in place.
Of voting early. It's worth pointing out that every single voter in the Commonwealth has the option to cast their ballot on election day. The statute
doesn't matter if you know what you're voting for, you can vote. Doesn't really matter if you know what you're voting for.
The opportunity to participate in the election early. That's why it's called early voting. And indeed, Black's Law Dictionary defines early voting as early participation prior to the election. And so there's a consistent understanding across law that early voting is participation in the election before the election. And so, but again, to your policy point, I understand. But
it's not a policy point. It's what does the word mean? That's a legal question.
I agree, Your Honor. And so that's why the text is the most important source that we have here. And again, those 5 separate provisions of the Constitution that define election or a word that's closely related to the word election.
Recognizing that text is most important. If you look at the General Assembly debates over the 1971 Constitution, didn't at least a few of the members say that the reason we have the intervening election requirement is so people will know when they vote how incumbent members voted and allow their opponents to say they would have voted differently. I mean, that's what they said on the floor, correct?
I am aware of one statement to that effect, and it was during a debate about a separate provision about Article 12, Section 2 about conventions. So first of all, I don't think that statements by individual legislators can overcome the clear text of the Constitution.
I agree with you on that.
So I'm glad we're in agreement. Given that, I don't think that those spare statements can overturn the text. And second, we have again the absence of a waiting requirement for the intervening election. So the 1971 Constitution intentionally removed a publication requirement that had previously existed for 90 days. And not only that, the 1971 Constitution includes exactly the waiting requirement that the challengers here wish there was before the intervening election. It includes that prior to the submission to the people. There has to be 90 days. And so the drafters of the 1971 Constitution knew exactly how to put in the waiting period that challengers try to impute into the text. They knew how to do it expressly, and they declined to do so with respect to the intervening general election.
Do you agree that by statute, the General Assembly may prescribe the manner in which the amendments are submitted to the people?
Yes, Your Honor. And that refers specifically to the manner in which the proposed amendment, after it has been passed the second time, how it's submitted to the people.
Recognizing that there are retroactivity, repeal issues, and all kinds of other things. As a factual matter, did the trial court correctly find that the things specified in 30-13 as it was in effect in October and November of 2025 were not done?
So it was not published 90 days before the intervening general election.
It wasn't posted by the circuit court clerks. Your position is that that is of no legal significance, either because of the repeal or because it doesn't provide the remedy. We tend not to treat shall as mandatory in such a circumstance.
I think there's a deeper structural constitutional reason that I think is more important. The deeper structural constitutional reason is that Section 30-13, which requires publication, or did require publication 90 days prior to the intervening general election. The constitutional basis for that was a publication requirement in the 1902 Constitution that was repealed. Now, the fact that the 1971 Constitution eliminated that constitutional provision did not by itself repeal Section 30-13. However, what it did do is it meant that Section 30-13 can no longer be a legal precondition for the validity of the constitutional amendment's ratification. To interpret Section 30-13 to condition the ratification of a constitutional amendment would be akin to the General Assembly passing a statute that says that in addition to the requirements of Article 12, Section 1, the people have to vote in favor of the proposed amendment twice. That simply cannot be constitutionally added to the clear and comprehensive framework that's laid out in Article 12, Section 1.
And who goes to the courthouse to get their news anymore anyway?
I think that's right. So the status of Section 30-13 at this point is, well, it's now repealed, as Your Honor referenced. In addition to that, it may have served the purpose before. I think part of the reason why the General Assembly has now repealed Section 30-13 is precisely because everyone in the Commonwealth knew about this without going to look at the door of the local courthouse.
I mean, in colonial times, market days, and people would go to the courthouse, and there was a big, to do, and people would learn about different things at the courthouse. Well, that's not.
Yeah, that's exactly right. I see that I'm running into my reply time. If there are any other questions. Thank you.
Thank you.
Despite the fact the Constitution requires those postings, it's in the Constitution. It's what it still requires. You don't like it, change the Constitution.
Good morning, and may it please the court. Tillman Breckenridge for the Commonwealth. I'd like to begin in the intervening election issue, and then happy to answer any questions on any of the three issues. The reason for starting with the intervening election issue is that I'd like to break down the arguments on how each judicial philosophy applies, given the fact that there's been some discussion in the briefing about purposivism versus textualism and things like that. I'll start though with textualism and then work my way to purposivism. As a textual matter, the Constitution is pretty clear, as Mr. Seligman broke down. It states that the next intervening general election will be of the House of Delegates, and the House of Delegates is elected on the first Tuesday after the second Monday in November. Always hard to get that one straight. But given that, you also have other provisions in the Constitution that establish that by general election, it means the first Tuesday after the second Monday in November. So, for instance, the 1-year residency requirement establishes the nature of the election and the fact that one is elected on that day, election day. And so now, under the new regime that the respondents suggest, I wonder if we would then be stuck with a 1 year and 45-day residency requirement.
I'll ask you the same question. Why isn't it a natural reading to read the phrase election, the noun, as the process, and the verb phrase shall be elected as indicating the end of that process, or at least the voters' participation, the group that is the passive verb is referring to do something, shall be elected, is the end of that process. Because even on election day, you're not elected, and because you're not elected until you're certified, right?
That is correct, Your Honor. And that's why I want to use the Constitution's text primarily, because the Constitution treats both the word elected and election as that first Tuesday after the second Monday in November. But to the extent that we're talking about natural reading or dictionary definitions, if you go to the 1971 Oxford Dictionary, it defines an election as the formal choosing of a person for office, dignity, or position of any kind, usually by the voices of a constituent body. Now, I realize that could have gotten a little bit confused because the respondent's briefing appears to, as best I can tell, mush together a few definitions or maybe a couple definitions of election. I couldn't get a hold of a 1978 Oxford Dictionary.
But just to be clear, much like the Legislative Leaders Council, you agree that for you to be correct, people casting votes are not actively participating in the election when they cast their votes.
No, I disagree with that, Your Honor.
Okay. How am I, if I voted on October 21st, actively participating in the election when I cast my vote if the election hasn't begun yet?
Because you cast your ballot early, but your vote isn't counted until election day.
Well, that's the difference between casting and counting. I understand that your position is they're counted on election day. My question is, am I actively participating in the election when I vote? That seems to be the sine qua non of an election. I go and vote.
Well, I disagree, Your Honor, because you're casting your ballot before election day. Your vote your vote actually happens on election day when your ballot is counted.
So
that is a vote.
So your interpretation of the provision is that we literally could have an election where every single vote is cast before the election actually even begins.
I guess in the abstract, perhaps if everyone voted early.
That seems a very extreme definition of election to me.
It's the definition of the election that the Constitution gives, Your Honor. And if we are going to take a sort of living constitutionalist approach to it, where the definition of election kind of changes because we have new early voting procedures, then that would be sort of more of a fairness argument. And if we go to that direction, then I would say that I think it's inherently fair for anyone who casts their vote early, as I have in the past many times, to say that they should have to say to themselves, I am accepting that there's something might happen in the interim that is significant that might change my vote if I had waited. And so that includes an October surprise or the death of a candidate. And so the respondents have, kind of said, oh, a mere October surprise. So they seem to be suggesting that there's an importance difference and a tough challenge to figure out what the standard would be for that. But I would have trouble figuring out something that's more important than the death of the candidate you voted for.
What is your position, your client's position, regarding a constitutional amendment that is adopted at 6 p.m. on election day with an hour left at the polls? Is that still the next general election? Because, hey, you could have waited until 6:59 to go to the polls to vote. Therefore, that's the next general election because there's still 60 minutes left.
No, Your Honor, because the Commonwealth's position is to base the decision in the text of the Constitution, which establishes that election day is the election. So anything that gets passed must be passed before election day.
We've talked text. What about purpose? So one argument is we need this delay so that there's time for voters to educate themselves for debate, number one. And then number two, so there's accountability. So if the legislature swept on a tide of passion does something that the voters decide is bad, there's the opportunity then to hold them accountable in the next election. So we have text. You've addressed that very well. Help us with the purpose aspect of it.
Sure, Your Honor. The two answers to that, and both are based, well, going with the purpose reason. One is based in establishing what the purpose really was, and then another based on even if the purpose was as stated, it would not be served by affirming the court below. So to go to page 498 of the debates where Delegate French Slaughter expressed the purpose of that provision, there were a few words left out in the respondent's brief, so I want to give the whole quote. He said, not only would there be an intervening House of Delegates election where you might be able to get the sentiment of the people on an amendment you had acted on previously, but upon reflection, the General Assembly might decide not to submit the amendment. So that you might get what the people think, and upon reflection, the General Assembly might decide not to submit the amendment. Suggests that there should be some intervening time, and that's the issue, is to provide an intervening time period for the General Assembly to change over to a new General Assembly, maybe hear from constituents, maybe not. But then 2 pages earlier, there's the discussion of the publication requirement and whether there should be a publication requirement. And Mr. Slaughter states in no uncertain terms that the whole reason for removing the publication requirement from before the next general election issue is that the idea is that the people get educated before they vote to ratify it. And so therefore, that is when people need to be educated, is when they actually vote. And so if we're talking purposivism here, if we're talking about the purpose of protecting the people's vote and protecting the people's ability to weigh in, then I feel like it would be patently unfair to override the people's vote because of a concern that they had not gotten to the opportunity to voice their opinion months earlier.
Regarding the special session surviving the convening of a general session, do you have any authority other than constitutional silence?
No, Your Honor, there's no authority one way or the other on it. It really just comes down to the fact that, and there is one thing I do want to correct on the record about that, though. There's a lot of discussion of 611 or 612 days of continuous session. But to be clear, the legislature did business a grand total of 14 days. They were not.
But contends they were in session the entire time. They didn't have to pass a new resolution by a supermajority or have the governor call them back in at their option. And weren't they actually pro forma continuing the session the entire time?
They recessed the session several times. But the bottom line is, Your Honor, they were actually in session for 14 days. So
the session lasted the entire 2 years. Whether they did business during the session is a different question.
Well, perhaps, Your Honor, but the bottom line is there's no reason to start talking about how this legislature created some non-citizen or professional legislature. They were in for 14 days. They didn't violate any concept of a citizen legislature by remaining in recessed session for a long period of time. They only actually did business for 14 days. And so given that, and given the fact that there is no authority one way or the other, but the bottom line is that they weren't converting themselves to a citizen legislature. I really don't think that there's any constitutional argument that they somehow violated their powers as a legislature to continue the session. Unless there are any further questions.
I have one, but I didn't want to eat into your time on the 3 issues that are before us. My understanding is there's additional lawsuits that are working their way through the courts. Can you give us a just very quick update on essentially where those are, if you're able to?
Yes, I am, Your Honor.
Okay,
there are 2 other lawsuits working their way through. Currently, one has been filed. The Commonwealth has filed a notice of appeal in the Court of Appeals. This court then certified it to itself. We currently have a motion to expedite that's pending and awaiting a ruling on that. There is also a litigation on the compactness of the maps. The Circuit Court of Richmond ruled yesterday that the maps are both compact enough, and the constitutional amendment abrogated the compactness requirement for this anyway. And we have not seen any response to that just yet, but that was yesterday.
Was that a final order on the merits or a final order on a request for an injunction?
That was an order on a request for an injunction, Your Honor.
So to the best of your knowledge, there's no final order in that one.
That is correct, Your Honor.
A lot of balls in
There's
the
a lot
air.
going on. Yeah.
It's helpful to have the latest on that. So thank you.
They've been keeping me busy.
We figured you'd be the one who would know.
Fair enough.
Thank you.
All right. Thank you.
Thank you, Counsel.
You're watching Virginia Insider's coverage of the Supreme Court oral arguments today on the gerrymander, April 21st gerrymander. Thank you all for being here. Following along with many of you are in the chat. And we just heard from the Commonwealth, Attorney Jay Jones's general
Good morning, Madam Chief Justice, and may it please the court. Thomas McCarthy for the appellees. The Virginia Constitution and Code delineate a very specific and detailed process for amending the Constitution, a process that proceeds in 2 stages with an important role to be played by the voters of the Commonwealth in each. The court held nearly half a century ago that Virginia voters are entitled to strict compliance with that constitutional amendment process. Yet a bare partisan majority of the General Assembly rammed the proposed amendment through the legislature, departing radically from the mandated constitutional amendment process and historical practice, severely undermining the rights of Virginia voters, and indeed undermining confidence in the results of the very referendum itself.
When you say a bare partisan majority rammed it through, that sounds like an argument about something that they shouldn't do, but we're only concerned with what they couldn't do. It doesn't matter that it passed by 1 vote, and if it only passed by 1 vote in the General Assembly, if they have the power to do it, or if they followed the right procedure. They clearly have the power to do it. The question is, did they follow the right procedures? So I would ask that you focus your argument on that.
Certainly, Your Honor. As an abstract matter, certainly they have the power. The legislature has vast powers. But for that very reason, Virginians have long distrusted legislative power and feared the tyranny of permanent legislatures, which is why there are strict limits in the Virginia Constitution on when and how the legislature can meet. As I think was noted earlier, our Constitution provides for a citizen legislature. Right? What it does is regular sessions are only once a year, second Wednesday of every January, and only for 30 or 60 days. So the default position is that the legislature is not sitting. There is, of course, also the Constitution provides for special sessions. The governor may convene a special session of the General Assembly in the interest of the Commonwealth when the interest of the Commonwealth may require it. And the governor shall convene a special session upon the application of 2/3 of the members elected to each house. Now, the proposed amendment violates the Constitution's limitations on special sessions in two ways. First, it's the product of an improperly expanded special session. Starting with the text, special sessions are special. That's why a 2/3 majority at each house is required just to assemble the body outside of its normal course. Both Black's Law and the General Assembly's own Legislative Information Service define special sessions as limited to specific issues. Not only that, but both the General Assembly in its application and the governor in calling the special session recited the same limited purpose: to consider budget bills.
It was a budget session.
As noted in our briefing, both Mason's Manual of Legislative Procedure, which, by the way, the Senate uses to construe its rules, and state court precedent construing similar provisions, they say that limiting the scope in this way, as they said that the scope of special sessions is limited to the expressly identified purposes in those calls. The substantive limitation on the scope of special sessions is not just there, it adheres in the very structure of Article 4, Section 6, most particularly in the dual 2/3 requirement. That 2/3 requirement is important. When an application for a special session is proposed, all members of both houses.
But that doesn't apply if the governor calls it, correct?
I'm sorry.
If the special session is called by the governor, it's a one-person call. He doesn't need the supermajority in the House. It's if the General Assembly wants to do it, they have to do it by supermajority. If the governor calls it, he just calls it.
That's correct. And this is one that was proposed by application of the General Assembly. So we're in the 2/3.
But for an argument that the general necessarily ends a special session, their position is that this is the governor's special session, so we didn't need a supermajority to address it.
So this was certainly not the governor's special session. This was the General Assembly's special session. They called for it by a joint resolution, HJR 6001. I'm sorry, HJR 4 in April of 2024.
Okay.
They called it. They said it was for budget bills. The governor then responded, as he has to do in the process, and actually calls it. He has to convene it. Then he doesn't have an option. It's not his. It's the General Assembly's. That's why the 2/3 requirement applies. Now, again, the 2/3 requirement is very important. As I was getting to, when an application for a special session is proposed, every single member of each house has the opportunity to approve or disapprove of the issues that are proposed to be taken up, meaning that a minority in either house, right, 1/3 of the body plus one member, can block that proposal. So to allow special sessions to address issues outside of the scope of its application would flout that 2/3 dual house requirement in the special session clause. In other words, HR 6007, which was the first supposed passage of the proposed amendment, is invalid because it's not a budget bill. Now, there's a narrower argument on the scope of the special session, and this is the one adopted by the Circuit Court, which, by the way, we did not abandon. It's in our brief from pages 17 and 19. We discussed what the Circuit Court did, and we endorse it. The argument is that the special session exceeded its substantive limits as approved by 2/3 of both houses in HJR 6001. HJR 6001 expressly limited a special session to consider certain things, budget bills and 4 other items, which are not relevant here, but it was memorial resolutions and judicial appointments, other appointments that required confirmation of the General Assembly, and internal business. But in any event, it definitely did not include a proposed amendment or anything about redistricting. So HJR 6007, again, exceeds that substantive scope.
What does the historical record tell us about the General Assembly taking on additional legislation beyond the stated purposes originally? And is there a historical track record one way or the other of this being an established pattern, or is this completely unprecedented, or what?
Well, as far as we can tell, it's unprecedented. And petitioners do not cite a single occasion where a special session went outside of its bounds in this manner. And not only that, they certainly don't have any judicial precedent that endorses that.
All
So
right.
we think what there is an unbroken historical practice of doing what we say is required by
Because
the
that can inform the reading of a text.
Yes,
when
absolutely. Certainly, text, structure, history, it's all relevant when construing constitutional provisions, especially when you're talking about a long history like this is.
Is the resolution for a special session that we're talking about, is it a purely legislative act? Why isn't it fair to allow them to the General Assembly to interpret its own rules and procedures if it's a purely legislative act with no other branch involved?
Well, it's not simply a purely legislative act in the sense that there is this 2/3 requirement in the Constitution, right? That's a meaningful, that's where the substantive limitation on special sessions inheres in that, right? For this very reason that, I guess maybe put it this way, neither HJR 428 nor HJR 6001 would have yielded 2/3 support if a proposed amendment for redistricting were on the table. I don't think anybody would suggest they would have passed. So allowing a bare partisan majority to reconvene that special session and pass HJR 6007 by simple majority absolutely just eviscerates that requirement. It's acting as it's not even there in the Constitution. And I think that this court should not condone or countenance that, especially when the people are ultimately the ones who possess government power. The court said it itself in Staples. The people are the ones who hold the power to amend or modify the Constitution. And that's exactly why this court in Coleman said that strict compliance is required with all specified procedures. It didn't say just the ones that are in the Constitution, but all of them, because it's ultimately for the protection of the people, because it's in the people where the power lies. Now, I'll move on to the intervening general election. Well, actually, before I do that, there's also even setting aside the substantive limits on the special session, there's a timing limit as well. And I think Justice Russell, you referred to it earlier. That is, if a special session is open and it runs into the convening of a regular session, collides with it, the special session is terminated then. This is clear both in Mason's manual, which again the Senate relies on, and state court precedent construing similar provisions. And not only that, but there's an unbroken historical practice just like this. There is no example, and petitioners cannot cite a legitimate one, of a special session that continued to act during a regular session or after a regular session when it started before. The historical practice is that if a regular session adjourns, then you would start a new special session. But again, then you either need the governor to call it out of necessity,
And
or the General
practically
Assembly out of 2/3.
speaking, once you are in general session, you can take up anything you want.
Exactly. So it really makes no
then the
sense.
floor is wide open to do whatever you think you need to do.
That's exactly right, Your Honor. So it doesn't even make sense. It's sort of a nonsensical position to say that the special session exists through a regular session, not to mention remaining open in session, maybe not actually on the floor, but for 612 days. Now, even aside from that, the proposed amendment is void for another reason, because there was no intervening election. Under Article 12, an amendment's second passage must take place after the next general election of members in the House of Delegates. Now, to construe the word election, we begin with ordinary meaning. Webster's, Oxford, Black's Law, they all define election to mean the entire process by which votes are cast to determine a winning candidate.
Right? There's campaigning, there's ads, there's events, there's ballots being cast.
45
So then
days
the
of early
chief argument
voting.
and responses, but there's a specific meaning to that, to the Virginia Constitution. So that's the main argument on the other side. We
Right.
have to construe it as a whole.
We certainly do construe legal documents like constitutions as a whole, but I think that petitioners are taking out of context. For number one, as Justice Russell pointed out, it's not even the same word in the House of Delegates and the Senate provisions in the Constitution. It says elected, which is something different. But not only that, but almost every provision they cite, it's about election day or the day of the election. And that is a different term than election itself. Election itself has a meaning. It's known everyday understood meaning is the combined actions of the voters and officials to produce a final selection.
And
that's
speaking
why-
of the historical record, I'm not aware, but I may be mistaken, of an instance where the General Assembly adopted this particular process. In other words, where there's an ongoing, there's voting. I don't want to use the word election, but where there's people are going to the polls to cast their ballot. There's campaigning events going on, pro and con. I'm just not. It's doesn't address a constitutionality per se, but I'm not aware that this process was ever used before. Is that correct?
That's correct. This is unprecedented. In fact, this amendment process is unprecedented in several respects. This is just one of them.
All right.
But this meaning of election is consistent. It's consistent with the common usage of the term. It's consistent with how courts use it. I mean, in one of the preeminent election cases from the U.S. Supreme Court, Foster versus Love, the Supreme Court said that defined election as the combined actions of voters and officials to make a final selection of an office holder. The Fourth Circuit recently in Pierce versus North Carolina Board of Elections said the election was happening right now because early voting in person had already started.
The fulcrum on which the next general election argument turns, as I take it, there's no real disagreement between the two of you. If voting before election day is part and parcel of the election, if it is participating in the election at the time you win, if it is putting your ballot into cold storage and it doesn't take any significance on until election day, they win. Is that it?
I think there's a little bit more on our side, Your Honor, to be fair, because it's not just the word election. We're fighting over that, but we also have the word next, which means something. Also on our side, I think that the whole purpose is on our side as well. And on that purpose, there was some discussion earlier about the proceedings and the debates of the House on this part of the Constitution, and the point was that it was to get the sentiment of the people. And I think petitioners said something to the effect of, "Well, it only says they might get the sentiment." That's not to mean that the voters might or might not get the information in time to be able to make a decision in an informed manner. It's about they might or might not express their will through their vote in that election a certain way or another. Voters vote one way or another for lots of reasons. So they might or might not get the sentiment based on this proposed amendment or that proposed amendment. But 100%, the purpose of this provision is to make sure the voters are informed.
One thought occurred to me on this point, which is it's one thing when you have an ordinary election and there's a swirl of issues, et cetera. But when you're amending the Constitution, that could be for generations to come. Hence the requirement of strict compliance, because it's hard to undo if it turns out to be ill-advised. And so a vote on a with constitutional implications may be different than an ordinary vote on general public policy questions.
Indeed. And that's why it needs to come before the voting begins, so people have an opportunity to exercise that right meaningfully. Take Camilla Simon, one of the plaintiffs in this case. She is a regular Democratic voter. She is in support of nonpartisan gerrymandering, like 2/3 of the Commonwealth. She voted early in the 2025 general for her delegate, Rodney Willett. After that, in the waning days of the election, it was Mr. Willett that introduced this new proposed amendment. And she was very unhappy about this. She wished she could redo her vote, but she couldn't. She was denied the opportunity.
Counsel, did the trial court accept that factual finding?
It did. It was uncontroverted. It was sworn in a verified complaint. And I should note that petitioners had the opportunity to seek discovery or ask for a deposition. They didn't either. So they waived their opportunity. But more to the point, I think they probably waived that opportunity because they knew there was no basis to challenge it. In any event, she, like a million or more other people, voted before this proposed amendment was ever even proposed. None of these voters had any idea this was coming. And that's not how the process is supposed to work. Because as I mentioned before, it's the people of the Commonwealth, the voters, who possess the power to amend or modify the Constitution.
And the Democrats and Jay
denying
Jones says
them
none of
the
those votes
knowledge
matter.
that this proposed
That
amendment
doesn't matter.
is coming through should undermines the whole process.
Regarding the 30-13 requirement, your opponents have conceded that the steps laid out in 30-13 weren't complied with. But it would strike me, but no remedy is provided for in the statute. It would strike me as pretty extreme for us to say that one rogue circuit court clerk just refusing to post it on a courthouse wall stops the entire Commonwealth from ever considering a constitutional amendment. And that would essentially give a circuit court clerk veto power over amending the Constitution. Isn't that too extreme given our cases regarding shall as directive rather than mandatory to government officials?
Your Honor, I don't think it is too extreme. And there's a few reasons why. For one, petitioners point out that the rule, the duties that are provided in Section 3013 used to be a part of the Constitution. So they were a part of the Constitution, then they became part of the code as part of the 1971 amendments. Okay. There's still the law of the land.
Well, right.
And not only that,
there's no question the clerk is supposed to do it. Shall directs them to do it. They must do it. But the question is, if one circuit court clerk, whether to thwart a constitutional amendment or just because they forgets to post it 90 days before, there is no, then the whole rest of the Commonwealth can't amend the Constitution. That seems extreme.
Your Honor, I understand that your hypothetical is kind of an extreme one. Two things.
But it's your position, isn't it?
Well, two things, Your Honor. One, the point I was getting to is that Coleman requires strict compliance with the entire process. But the second is this. This is not at all like that. This isn't like one circuit clerk somewhere in the Commonwealth only put it up 48 days ahead of time or something like that. It was never posted, ever, anytime.
But strict compliance, one doing it on day, everybody doing it correctly, and one doing it on day 89 is not strict compliance.
So
so it seems to me you got to buy all of it for you to be right. That one rogue clerk can stop all of it.
Your Honor, I don't think that's the case. Now, although strict compliance is the rule, there may be circumstances like the Ragland case indicated where substantial compliance might be in order, where there is like maybe one clerk who's a couple days late, because I can promise you if every other clerk in the state did it, or the Commonwealth, I should say, and somebody forgot, they would know the next day and they'd put it up.
And the point of this, though, is to provide notice to the electorate, right?
That's exactly what it's for.
So we have a lot of cases dealing with statutory harmless error, right? So there's a statute that says do this, government official, but through neglect, whatever, they didn't do it. And then we say, okay, well, was that harmless? And anyone who's paying the slightest bit of attention to the news cycle knows about this constitutional amendment. So what about the argument that, okay, well, sure, they were supposed to do it, but I mean, leaving to the side the retroactive repeal. But really, I mean, now we get our news through social media, through news outlets, through the internet, through whatever. So would it be harmless? Could it be harmless error?
Certainly not in this situation. First of all, it wasn't inadvertent here. They just did it this way. It wasn't because somebody forgot. And second, it's not harmless at all because of people like Camilla Simon, because there was more than 1 million people who voted before this thing was ever even proposed. This is not like, maybe they did it a couple days late.
That argument goes to the timing, not the failure of the clerk of the House or the clerk of a circuit court to do the steps in 3013. That goes to next general election more so, doesn't it? Because she voted. But
I think it goes to both because the 90-day notice is supposed to be to make sure that the voters are informed and honestly to allow time for campaigning, because that's when a lot of this comes out. I mean, there are lots of voters across the Commonwealth who are not totally educated on all the events going on in Richmond.
And because some people got to vote on it and then some people
didn't. The Commonwealth
didn't.
needs time for the whole thing to be aired out. That's the whole point, is to get the sentiment of the voters. The information needs to be in the hands of the voters in time for them to make reasoned decisions and to actually vote. And that's what's missing here. And the point I was making to Justice McCullough was really about his harmless error analysis in a way. which is about, okay, what's the actual effect and whether it was inadvertent or not. And I think on that, it doesn't work here. This is a case where it wasn't inadvertent at all. And there's a massive error when over 1 million people vote without this information. In short, Your Honors, the proposed amendment is invalid for several reasons, any one of which is sufficient to invalidate the proposed amendment and require invalidation of the vote. Before I close, I want to say something about the Commonwealth. It's often said that ours is a government of laws, not of men. Sadly, that's not the case. If a bare partisan majority can circumvent the constitutional amendment process and undermine the rights of the people, in whom all government power ultimately rests. Also, that partisan majority can transform our system from a nonpartisan one where the voters select their representatives into a partisan one where the representatives select their voters. We ask that the court enforce the constitutional amendment process by affirming the decision below, declaring the proposed amendment invalid, and enjoining the certification of the election. Thank you.
Thank you, Council. Rebuttal, 2 minutes and 1 second.
Thank you, Your Honor. So just a few points in reply to establish that the people did, in fact, validly ratify the proposed amendment last Tuesday. First, I want to reiterate the fact that the challenger's sole argument with respect to the scope of business of the special session at which the General Assembly passed the proposed amendment the first time is that they purportedly exercised a power not found in the text of the Constitution to limit the scope of business in that special session. Now, I just want to point out that House Joint Resolution 428, which is when the General Assembly applied to the governor for that special session, says, and I quote, that the business shall be to consider such matters as are provided for in the procedural resolution adopted to govern the conduct of business coming before the special session. So in the document that was voted on by a 2/3 majority, it refers then to the procedural resolution, which the General Assembly then shaped pursuant to its own procedural rules. So for them to win on that point, it has to be the case that the 2/3 majority power refers not just to the convening, but also textually to a power to limit the scope of business, and they have to stack inference upon inference to say that 2/3 majority request did so.
So the General Assembly is the master of its own operations, and if they wanted to close the door more tightly, it could. If it wants to leave it ajar, it can.
Yes, that's correct, and they can change that by majority vote at any time. And so I think that
But in other words, if they had a pretty airtight resolution saying we're only going to look at this one thing and absolutely nothing else, then you might agree. And
no,
you would not.
No, so I'm saying
All
that their argument fails for two independent reasons. And the first is that the Constitution doesn't give the General Assembly to limit business in the first place via that 2/3 mechanism.
Thank you.
Then with my few remaining seconds, I'd like to just refer to federal law. So federal law defines the election as the day of the Tuesday after the first Monday in November. And this goes back to 1872 when they defined the election as the day for that day as the day for the election. The federal cases are unanimous on this. Indeed, the Supreme Court heard a case last month concerning, this is Watson v. RNC, concerning whether ballots that are mail ballots that are received after Election Day are consistent with the federal Election Day statute, which again states that the day for the election is the second Tuesday in November. And it was agreed by every single party that early voting is consistent with the day of the election taking place on a single day in November. And so the legal meaning of the word election is unanimously agreed upon to be a single day in November. That defeats our argument. Finally, I think that it's important to recognize that
Counsel, your time has expired.
Thank you, Your Honor.
Thank you.
So you're hearing them say single day in November, but you're also hearing them say pushing 45-day early voting period.
All rise.
All right, folks, that wraps up the oral arguments in the Virginia State Supreme Court case of this illegal gerrymandering that we've seen this April 21st, illegal gerrymandering going forward. The Supreme Court will just heard the arguments. You just heard them say both sides, Jay Jones, his team, and the yes vote representing the yes vote, and the Michael Thomas Gillespie of Hart, Pyatt, and Thomas argue on the side of the no vote there. And essentially what this is coming down to is when the General Assembly follow the correct procedures to get this on the ballot during a special session of the General Assembly, a special session called for budget purposes. And when they convened in October of 2025 to reconcile the budget, that while they were there, they said, oh, by the way, we're going to put a gerrymandering referendum on the ballot for people to vote on in the following year. And they decided to do that on Halloween after early voting for the November 2025 election was already underway. Look, Halloween, October, the end of October, and then you have the election day, which they spent so much time focusing on, was just days away. So essentially what they're saying is the people who cast their ballots early during the early voting period, that 45-day early voting period, that their votes didn't matter, that they should, even though they didn't know what they're voting for, they had, it doesn't matter because all the votes, no matter what they're voting for, no matter what it is, happens on election day, which was November 4th, 2025, the second Tuesday after the first Monday is what they said. So you can't have it both ways, right? You can't say in this case, well, election day is election day, and that's the end all be all. But then also at the same time, say, well, we need 45 days of early voting. We need a 45-day early voting period, longer than any other state in the U.S. You can't have it both ways because if anything, this is an argument to end early voting, especially for that long, for that wide open of a period. Because what happened here is people voted during an election. They started casting their ballots on September 19th of last year, 2025. And they walked into the polling place and they cast their ballot on exactly what the gubernatorial election and the House of Delegates that were up that year in 25. But when early voting started, they had no idea that this redistricting, this gerrymander was even a thing. And you had a governor, Abigail Spanberger, a soon to be elected governor, who was telling TV reporters that she had no intention of doing this, of having any sort of referendum. She was saying that she had no plans to do it, that was not necessary. And they talked a lot about what you heard in the news cycle. You talked about, well, people don't go to the courthouse to get their news anymore. They get their news on social media, and anybody who's barely paying attention would have learned about this. Well, come on, if you're barely paying attention and you're tuning in and out and you're hearing just sound bites of the candidates during the election season. Well, WJLA, Nick Minock, got a soundbite of Abigail Spanberger saying she had no intention of doing this. So this was not even a thing. And then for the Democrats in their special budget session to go in and decide, well, you know what, why we're here, why we're at it, let's just go ahead and gerrymander Virginia. Let's do it. We've got the super. We're in charge. We can do it. Let's do it. And they did. So that essentially is what it boils down to. Did they do it correctly? Again, they're not challenging the no vote here, the no side, conservatives, the no crew. They're not challenging the maps as egregiously gerrymandered as they are. You didn't even hear a lot about the budget. You didn't hear about the ballot language. Come on. We walked into the ballot and we read one of the most confusing just stupid ballot questions. I mean, to restore fairness, and it was engineered to be confusing. It was engineered to, when you walked in there and you read restore fairness and you didn't see the maps because they wouldn't show you the maps. That was purposely kept out of the polling booth. I mean, hopefully there was the no vote table out there that showed you what these maps look like before you walked in. But when you got inside, they were nowhere to be seen, and that was by design. So when you got in there and you said, well, restore fairness, the ballot question, as confusing as it was, said, well, my goodness, who doesn't want to be fair? I'm for fairness, right? Everybody should be fair. Yeah, I don't really know what this means. I want to make sure that I'm fair. And that's why it was worded the way it was worded, to strike confusion, to cause confusion. This thing, again, if you go back to the results now, we're about a week out from week since the election, this thing barely got by 3 points. So this anomaly was a mandate. They spent tens of millions, over $100 million in getting out the yes vote, and they barely scraped by with a 3-point win. So in no way is this a mandate. And a lot of people had thought, a lot of conservatives on the no vote side was being told, hey guys, this is going to be a blowout, and it's not going to be pretty, because the yes vote's going to come out in all of the Democrat areas in Northern Virginia, Hampton Roads, Richmond, and they're going to blow us out of the water. And that did not happen, because conservatives across Virginia stood up to this, and for what it was. This was a blatant gerrymander. It was an effort to remove representation. It was an effort of politicians to be able to choose who you vote for, and to tell you who your candidates will be, and to take away 4 of 5 sitting conservatives on the in the U.S. House of Representatives, leaving us with a 10 Democrat, 1 Republican map, taking away the most fair maps anywhere in the U.S., which was already 6 Democrats to 5 Republicans. So you had really a 50-50 map. Now, only 9% of conservatives will have a voice in Virginia because of that 10-1 map, if the Supreme Court of Virginia allows these maps to uphold. So we are waiting a press conference here from Ken Cuccinelli. We'll be taking you to that live when that happens. I'm going to go kind of share this with you here and kind of walk you back through how we got here. But if you are just joining us, hello and welcome to Virginia Insider. We have been watching live coverage of, listening to live coverage of the Virginia State Supreme Court, the arguments for and against the gerrymander that took place on April 21st, just last week. Welcome in. Please like and subscribe and tell us what you think here in the comments. Comment section's been very active here for the past hour and 10 minutes. So we do appreciate you being here. Thank you so much for your support of our channel. Folks, this channel really has grown because of what the supermajority in Richmond, the supermajority of Democrats in Richmond, have decided to do in terms of forcing this gerrymander down our throats, despite the fact we had a candidate as governor who said she wasn't going to do this. So the people see what this is. It is a blatant power grab, and this is why this channel has grown so fast, folks. I'll tell you, we had on March 1st. Right before the early voting for this April 21st gerrymander began on March 6th. On March 1st, we had 500 subscribers. Today, that number on this channel on Virginia Insider is more than 13,000. So that tells you how much this issue has polarized Virginia, and unfortunately now you're seeing neighbors in Virginia go after each other. It's unfortunately, it's becoming a North versus South thing, because you have the yes vote highly concentrated in the urban areas, especially in Northern Virginia, Arlington, Alexandria, Fairfax, Prince William, Loudoun, and then the no votes in the pretty much the rest of the state. If you get outside the urban crescent that is Nova, Richmond, and Hampton Roads, you get out into the rest of the state, and it's just a bunch of people who literally want to be left alone. They want government to leave them alone. They want government to stay out of their business and allow them to elect their own representatives and to leave this process up to an independent redistricting commission, which voters approved in 2020 by 66%. Every locality, every jurisdiction in Virginia approved the independent redistricting commission by 66%. Every locality except Arlington. Arlington, Virginia was the only county, the only jurisdiction that said, you know what? Politicians are the ones who should be able to draw the maps. Politicians are the ones that still should be able to tell you who you should vote for, who your candidates are. That the people should not be able to decide that. So Arlington was the only jurisdiction back in 2020 that said no to the independent redistricting commission. And now you see, what we've heard, what we've been reading over the past week here, potential executive order that could send Arlington and Alexandria back to DC to make DC square again, to restore what was originally the Washington City, what was originally the federal district, land ceded from Virginia to create land ceded from Virginia and Maryland on a permanent basis back then in the late 1700s to create the federal district, but later ceded back about 50 years later because Virginia wanted to have slavery and Washington, D.C. was a free territory that did not want slavery. So Arlington and Alexandria wanted to continue slavery. As we all know, the slavery trade in that part of Virginia was huge, and they wanted to continue that. And so that's why that land went back to Virginia and what it is today, Arlington and Alexandria. All right, so I'm going to go back here and take a look at this this timeline, and this is going to go back here. I don't know if I can get rid of this thing here, but this website here, Democracy Docket, has a timeline on how we got here. So going back to the October 28th, we have the proposed constitutional amendment is when they decided that they were going to pass this. It looks like the legal fighting began about that time. When we go up to the November 18th, plaintiffs filed for an amendment complaint proposed to dismiss. On December 8th, the plaintiffs filed their oppositions, proposed the whole deal here. The court will hold a hearing. They decided back in December of 2025 to hold a hearing on this. The plaintiffs filed an amended complaint and asked for a preliminary injunction, the plaintiffs being the no vote. On January 6th, this is when it all got interesting. In January, the plaintiffs filed from a motion for a temporary restraining order to seek to block the proposed constitutional amendment from being introduced when the new legislative session began on January 14th. On the 13th, the court denied the plaintiff's motion for a temporary restraining order. The constitutional amendment may be introduced when the new legislative session began. So you can see where the plaintiffs, the no vote side, tried to stop it then because it knew it violated the procedural norms from the Constitution. So they stopped it then, or at least they tried to stop it then before it was introduced during the general session in January. So we come, one of the first things that happened when the session started is the constitutional amendment passed the Senate. And then the courts on the 21st held a hearing on the plaintiff's motion for a preliminary injunction. Again, they're trying to stop it. The court found the bill on the 27th, they found the bill to amend the Constitution during the special session void and granted a temporary and permanent injunction in favor of the plaintiffs. So this was going back to the decision in Tazewell County by Circuit Court Judge Jack Hurley Jr. They found the Constitution, the session void. So the defendants, the supermajority of Democrats in Richmond, appealed, and the court's ruling the state at the Court of Appeals. The Attorney General Jay Jones seeks to intervene in the lawsuit on February 2nd. The February 4th Court of Appeals asked Virginia State Supreme Court to review the defendant's appeal of the lower court's order blocking the legislature's redistricting efforts. Plaintiffs do not object. The Virginia on February 13th, this is what has caused so much debate and questioning. The Virginia State Supreme Court back on February 13th allowed the referendum to move forward while the court case proceeds. So this is back when on February 13th is when the court we just heard from this morning decided to let the election move forward because they said, well, there's nothing that's been decided yet. And so we're not going to stop this thing. The voters should have a say. And that has really fueled the argument that we heard today, in addition to the yes vote saying, well, the election happened and we should count all votes because all the votes were filed by election day. You also have you have the yes vote saying that let's see here. Okay, I'm just checking something here as we wait for that press conference coming in from Ken Cuccinelli. We'll be going to that as soon as that kicks off. We'll be going to that here, just checking on that. Okay. But going back to my point, you heard, well, the yes vote is saying, well, the voters decided. The voters got a shot at this, and they're also saying, and that didn't happen in Texas. It was the court case. The courts decided in Texas. The legislature decided in Texas. They did not hold a referendum, but the Democrats in Virginia are saying we good liberals and Democrats in Virginia and in California, we put it up to a vote. And so no matter what happens, no matter how we got it here by hook or by crook, the people got a chance to vote, and we should respect whatever the majority wants. The majority in Virginia being by 3 points. Folks, I don't know of a better argument for the Electoral College than what we're seeing play out in Virginia right here and now. This is what happens when the majority rules. And this is why we do not have a democracy as many times as Hakeem Jeffries and everyone on the left continues to tell you, well, my democracy. Folks, we have a constitutional republic. Because if it was pure democracy and then it would just be mob rule, completely mob rule. And the map that we saw, and I'll pull that up here when we go here, but the map that we saw from last Tuesday's referendum, where the majority of the counties are one color, the no vote, and the minority of the counties are the yes vote. They rule because they have more population, and that is majority rule. That is democracy, and we do not have that. We have a constitutional republic. John Adams said, if you can keep it. We gave you a republic if you can keep it. And it's much different than that. My democracy is what you hear from the left all the time. My democracy. We don't have that. So here we are. That's the timeline today. But I want to also take you back to something that's very nefarious. So I can find this. It's when the Democrats, in power, moved. Okay, so this is back on November 3rd, and I glossed over this, but this right here, the Democrats back on November 3rd, they moved to transfer any action from the courts on this issue to the city of Richmond, where it says here, where the legislature conducts all of its business. Now, why do you think the Democrats want to move anything having to do with this issue, or really anything else in which they're arguing, to Richmond, to a deep blue city in Richmond, for their circuit courts in that city? Interesting. It reeks of bias right here. November 3rd, way back when, as this thing was just kicking off. You see that happened here. So, all right, folks, like I said, we're going to wait on that press conference. I'm going to check the links here to see when we have more coming up on that. I'm going to go into this here. And as we see here, as we have just again wrapped up those oral arguments, what do you think? I mean, do you think from what you heard there, you heard that the no vote, the conservators are saying, listen, if you're going to do this, you have to follow what the Constitution says. And even though maybe not, though it is a requirement for these notices of elections to be posted in every courthouse, and though very few people may go to the courthouse to get their news, the Constitution requires this to happen. And the conservatives in this case saying this didn't happen at all. And so it is one thing to say that, well, if it happened and maybe a few of the circuit court clerks didn't post it or posted it late, this wasn't posted at all. And the Virginia Constitution requires this to happen. And so what do you think? I mean, should this be allowed to slide because, well, it was just the way we were feeling, and well, it was something we decided to do during a special session? Or should the Constitution be held? Should it be viewed as a rule book, something to be upheld and looked into and adhered to, I should say, versus something to just maybe we'll consider it, maybe we'll do it, maybe if we feel like it? I don't know. Let me know in the comments what you think here as we continue on our coverage. This is Virginia's Insider's coverage of the oral arguments in the redistricting case here at the Virginia Supreme Court. All right, I got to sign into our Zoom here to get this press conference up here. Press conference set to begin at 10:30, so we'll just kind of getting all set up here, getting all logged in, and we will see from Ken Cuccinelli. Now, many of you have asked when we should hear something, when a decision will be made. From what I can gather, it could very well be into May before we get a ruling on this from the state Supreme Court. This is being held on Zoom, and I am now in password hell trying to log into this thing. About 5, 6 years ago, I used to be a real big Zoom user, and have since migrated to other platforms. So it's been a while since I've been logged into this application here. Okay, I think we're in. I think we are in. Okay, so we've got this press briefing beginning shortly here. Shout out to our friends in Colorado who gave the super chat here earlier. I put it up on the screen earlier in the show, but thank you so much for the super chat. Colorado is watching this closely. They are trying to redistrict here. Godspeed. So folks know that we in Virginia are not alone. We know that Florida is taking up their special session. President Trump was asked if he thinks Florida should redistrict, and he said yes, a resounding yes on this as the redistricting wars continue. Now, people forget. They always say Texas started this. Texas is the one to blame. Texas did this because they wanted to appease their master, Donald Trump. But in fact, New York started this back in the early part of this decade when New York created, they bypassed that state's independent redistricting commission and ousted several Republican seats in favor of Democrats, kicking this whole thing off back in the early part of this decade. But going forward to 2024, when the Fifth Circuit Court in Texas ruled that DEI could no longer be used to determine districts. They were called coalition districts is what they were called. And essentially, since 1988, districts had been drawn grouping together minorities of different minority groups in order to produce an outcome for a congressperson who would, quote, best represent that minority. Didn't really matter which minority, it was a group of minorities, and they would stack and pack these districts, packed districts, to get the outcome that they wanted for an election. And what the Fifth Circuit in 2024 ruled was no more DEI in map drawing, no more coalition districts. And so what happened was President Trump's team, ever on the lookout, they were on this, and they said, they called Governor Abbott in Texas and said, hey, listen, the maps that your state drew in 2021 are not compliant with the Fifth Circuit ruling. So would you redraw your maps? And Abbott said, yeah, we'll do that. And so they did, in response to what President Trump asked. What did California do? Well, they responded immediately and put Prop 50 on their referendum, sent that out to the voters. The voters in California approved what Virginia, similar to what Virginia did last week, to abolish their independent redistricting commission and strip 5 Republicans of their seats in California. Yes, there are a lot of Republicans that live in California, and they at one point had 5 congressional seats out there to represent them, and California stripped those Republicans of their seats. The voters in California did so to answer for the 5 seats Democrats were removed from in Texas. So California answered for what Texas did. What Virginia did, what Virginia is trying to do, is a blatant power grab. And the numbers bear it out. The districts bear it out. The arguments bear it out. All right, let's go here to this. See here. All right. Thank you for the super chat, Brandon. Angel 34. If we do not get the results until May, that affects signature gathering and campaigning for the candidates for districts that may or not exist. Well, it's a good point because, I mean, we have obviously the midterms. This is all about the midterms coming up. And you have Democrats who are announcing for these districts that are hanging in the balance of the Supreme Court decision. And so as they go around and collect signatures and donations and door knock and what have you to get support in their what will inevitably be in just about every one of these districts a Democratic primary, because this state has so many Democrats chomping at the bit to run for office, and so this is going to definitely affect their efforts to get on the ballot and to compete in that primary process. So that's a very good point. Thanks for the super chat. I really do appreciate that. All right, we are awaiting that press conference here. Kevin Cuccinelli has been all over this since the referendum announcement. The results came in for the referendum, and he has been pushing this, and so we are eagerly awaiting his reaction to what was argued here today before the Supreme Court. You'll remember Ken Cuccinelli was the Attorney General of Virginia from 2010 until through 2013. He was elected in 2009, and he served under Governor Bob McDonnell and Lieutenant Governor Bill Bolling when they were elected in 2009. Cuccinelli then ran for governor in 2013 and lost out to Terry McAuliffe, who went on to win that election in 2013.
Three cases, and then I'm going to dive into the oral argument today that occurred in the Virginia Supreme Court between about 9 and 10 a.m. this morning. You all know there was a referendum vote last week. The yes side won by about 3 points. And the process by which that referendum was brought about was very controversial for a variety of reasons. There are 3 legal cases running at the same time right now related to the referendum. 2 of them are related to the process of the referendum itself, and 1 is related to the new proposed maps advanced on a contingent basis by the General Assembly in the event the referendum is upheld. This is the 10-to-1 map that you have heard about. If the referendum is defeated, the map used by Virginia today, drawn by its bipartisan redistricting commission 5 years ago, would remain in place indefinitely until something else changed in the future, probably until the next redistricting after the next census. So first, what was before the Supreme Court today among all of the issues? There are 4 constitutional issues among the 3 cases, and there are 2 statutory issues among the 3 cases. Today, the Supreme Court heard 2 of the constitutional issues and 1 of the statutory issues. I'm sure you all saw the news last week from the Tazewell Circuit Court Judge Hurley, who has enjoined for now the certification of the election based on a third constitutional issue and a statutory issue related to the ballot language violating Virginia's plain English rule. And I'll get to that in a moment. And then the other case, there was a decision yesterday in the Richmond Circuit Court on the maps themselves. And the judge in that case, this was a motion for a preliminary injunction. So it's a higher bar, higher standard. Certainly found the plaintiffs harmed, but did not find them likely to prevail on the merits in attacking the map on two bases. First, Virginia's Constitution has a compactness and contiguity requirement, and the judge said that the proposed amendment effectively overrode that requirement of a fair map when drawing legislative districts. In the alternative, he said that the map complied with it. That was a circuit court ruling yesterday. That is literally the most recent decision of the three cases. We'll see whether those plaintiffs appeal or play out the whole case. So back to today, that's the three cases. That's all the issues. Now I'm going to list the issues all together. 4 constitutional issues. These issues are pinned to my Twitter page. They're still there at the top of the Twitter page, and I will relay them to you in chronological order. The first 2 issues, which were heard by the Supreme Court today, are that the General Assembly last Halloween, when it did what's called first passage of the amendment, was in a special session, and that special session had either terminated because a regular session had occurred prior to the special session, or that a 2/3 vote had been required to include matters like amending the state constitution in the special session, and neither of those happened. So that was the first constitutional issue, was the special session adequate and properly executed in a manner that would allow the first passage of the proposed amendment. The second constitutional issue, a little easier to understand, is that like many other states, Virginia's Constitution, and all these issues are Virginia constitutional issues, not federal constitution. Virginia's Constitution requires that the General Assembly pass an amendment before a general election, state general election, and we did those in odd years. You will all recall that Governor Spanberger was elected last year in 2025. That was the general election. And with that intervening election, second passage of the amendment with a new General Assembly has to take place with the exact same language. And the constitutional issue argued today in front of the Virginia Supreme Court was whether the 2025 election qualified as an intervening election for purposes of satisfying the requirements of Article 12, Section 1 of the Virginia Constitution, which is the section that deals with amending the Constitution. Again, that requires the passage of a proposed amendment, then the occurrence of an intervening election, and then second passage by the new General Assembly. Now, Virginia has 45-day open elections. So voting began in 2025 on September 19th, and over 1 million people had voted by Halloween, the point in time when the Democrat General Assembly first passed the proposed amendment. And so there were 2 word issues. What does election mean in this context? And what does next mean? It's like Mother's Night Out here, right? And those were both discussed heavily this morning. Those were the issues before the Virginia Supreme Court this morning. The questioning was focused well, really, it addressed all three issues, but it was focused first on the special session questions. Justice Russell asked if a yes vote, whether the outcome of the election was relevant to the legal consideration. And counsel for the Commonwealth, actually, a lawyer brought in from California by the Virginia Attorney General's office and sworn in for this case, admitted that the outcome of the election was irrelevant for purposes of determining the legal question of whether the referendum was done properly. And then they drilled down on the special session. Justice McCullough followed up and asked the question of, does a special session survive a general session? So in May of 2024, the special session was called to deal with the budget. They hadn't finished a budget. So that was a year and a half before Halloween of 2025. And the General Assembly is arguing that special session continues as long as they want it to, until they adjourn it or their session of the General Assembly ends, meaning when the new General Assembly is sworn in. The other side argued that special sessions are special. That's the point, is to do something in particular, and that when a regular session arrives where you can do anything by operation of law, that ends the special session. If that were true, then the 2025 regular session of the General Assembly would have ended the special session that the Democrat General Assembly is relying on as the vehicle in which it passed the constitutional amendment on Halloween. That was the first argument. And there seemed to be some dubiousness, at least among some of the justices on that point. But I would note in the argument, there are 7 justices, only, well, 3 made any comments or asked questions. Wes Russell and Steve McCullough, and the Justices Russell and McCullough, and then Justice Fulton as well, also asked a question. So I would note that both Justices Russell and McCullough came out of the Virginia Attorney General's office, which is for state constitutional issues, it is the place on earth with the most expertise on the Virginia state constitution, which is what made the hiring by current Attorney General Jones a little peculiar, to bring in an out-of-state counsel to argue the Virginia state constitution. It's not unprecedented by any means, but it was eyebrow raising in Virginia. That was a little bit of a surprise. The defendants here, the Commonwealth defending the referendum and its outcome, argued that with respect to the election, voters who vote early, those million voters who voted before they knew there was going to be a proposed amendment to the Constitution related to gerrymandering, that was at their risk. That was the defendant's position, is, they take the risk. If there's an October surprise, then they shouldn't have voted early. The early voting is just an option for their convenience, but the election, the defendants held, was election day. The whole election, for purposes of what is an intervening election, is the day they count the votes, election day. In fact, Virginia doesn't count the votes on election day because ballots can come in for 3 more days. But they relied heavily and almost exclusively on a Virginia statute. There's a federal statute that's very similar. On a Virginia statute that says election day is the first Tuesday after the first Monday in November. And same language as the federal election day statute. And they, that statute predates when we began with a 45-day election. There wasn't a lot of discussion of the fact that it predated the 45-day election, but they were blunt. Early voters vote early at their own risk. Justice Russell posed the hypothetical what if the General Assembly passed for the first time a proposed amendment to the Constitution at 6 p.m. on election day? Would that be sufficiently before the election? And frankly, the counsel for the defendants didn't answer the question. He dodged the question. He did not answer that one. So the third issue they dealt with is a state law in Virginia requiring posting, 30-13, requiring posting of proposed constitutional amendments 90 days before an election, which would have been before both the 2025 election and before the referendum. The discussion today was only about the 2025 election. Everything related to what happened in 2026 is in the case that's coming up and has been appealed from Tazewell, the ruling last week that has enjoined the certification of the election. So we'll see how that goes. And there was some discussion about whether a rogue clerk, for instance, who didn't post 90 days before could invalidate an entire referendum. And the counsel for the plaintiffs said, well, look, that's an extreme case. That isn't what we have here. No one posted 90 days before the 2025 election because it was impossible, because first passage had not occurred. And in the discussion, it was noted that it has never happened before in Virginia history that a General Assembly has passed a first passage, any passage, first or second passage of an amendment while voting was going on. That has never happened before. I do litigation in this area, and I am unaware of it happening anywhere else in the country. There was some discussion about what is the purpose of having an intervening election, obviously to allow the voters to weigh in if they want to. I should note, for those of you used to reporting on federal legal issues, that you often hear about legislative intent in federal discussions. Virginia minimizes the weight of legislative intent perhaps more than any other jurisdiction in the country. We rely much more heavily on the plain meaning of the words at issue. People don't typically seek out legislative intent unless plain meaning would lead to an absurd outcome of some kind. And that's not the case here. That came up from both, on both sides, meaning when both defense and plaintiffs' counsel were up. Defense counsel was defending the referendum, defending the speaker and the solicitor general on behalf of them. And the plaintiffs were Ryan McDougall, state senator, Republican state senator, and a member of the Legislative Redistricting Commission that drew the original lines that are in place today, as well as some voters. There was reference made to a Democrat voter who voted early in 2025 and was one of the plaintiffs. She had no idea it was coming. Nobody had any idea it was coming, say in September, for example. And her delegate proposed the amendment, Delegate Willett, and she was a strong supporter of the bipartisan redistricting effort. And had she known about it, she would have voted against Delegate Willett. But she had no knowledge it was coming at the time she voted early. And Justice Fulton really questioned this in the record. And the plaintiff's counsel, McCarthy, noted that all of this was in a verified complaint, which means the plaintiff swears to the truth of it, and it was uncontested by the defendants. So this was, some of the small number of facts that were in evidence, and it was obviously an important fact. I'm looking at my notes here. To give you a sense of the Virginia Supreme Court, when the defense, who are the appellants here, they brought the appeal because they lost in Tazewell Circuit Court. Virginia lost, the Republicans won. So Virginia got to go first. The defendants went first, the appellants, and then the plaintiff, appellees, went second. and the defendant appellants had reserved some time. When they got up to use their reply time, Chief Justice Cleo Powell said, counsel, you have 2 minutes and 1 second remaining in your time. So very particular. And when each side's time was ended, she cut them off and they cooperated, complied with being cut off there. I think that there was, when you look at the three issues before the Supreme Court today, the two constitutional issues was the special session properly executed so that the first passage was legitimate? The second question was, can the 2025 election count as the intervening election? Those are the two constitutional issues. There seemed to be more willingness on the part of the court, I'm drawing this largely from Justice McCullough's comments, to give more leeway to the General Assembly about how it conducts its own special sessions versus strict compliance, which is what the case law precedent says, and this was emphasized by the plaintiffs, strict compliance with the constitutional requirements for amending the Constitution, which were more at issue in the question of whether the 2025 election was an intervening election. And then the 90-day posting requirement and the statute has no remedy in it. So the question becomes, well, what do we do with this? That was much more uncertain. So I think if you were to see the Supreme Court rule that the referendum was improperly executed, it would most likely be on the election issue, most likely. I'm drawing a lot when only 3 justices of the 7 spoke, and it's dangerous to draw too many conclusions from oral argument. We're 20 minutes in, and I want to give you all a chance to ask questions. Melody, how are we going to execute that?
So we have, it's up to you, Ken. We have.
All right, we are
questions
watching
and-
I see the.
All right, so we're watching a press conference from virtual press conference from former Virginia Attorney General Ken Cuccinelli on the Supreme Court oral arguments this morning.
Nature of the legal issues at play in your observation of the justices, do they give any impression that they might rule to invalidate the referendum and render the Tazewell case moot? Again, only 3 of the 7 justices spoke, and Justice Fulton really just asked a follow-up question on the factual matter related to the Democrat voter I referenced, who was upset at having voted early as a strong supporter of the bipartisan redistricting and having not known that the gerrymandering amendment was coming. So you really only heard from Justices McCullough and Russell, and they are the 2 most conservative justices on the court, just for reference. But they're also the 2 justices on the Supreme Court who, by a long margin, have the most experience dealing as professionals before they ever became judges with the state constitution. Steve McCullough had a career in the Attorney General's office before he ascended to the bench, and Wes Russell litigated the state constitution, including one of its most famous cases in 2007, Marshall v. whomever, over a tax case, and he won 7-0 prior to his service in the Attorney General's office. It is not surprising that you would hear from them the most, but to your question, Joe, given the nature of the legal issues at play, in my observation, I guess my point is, all I really heard from was 3 justices. I was a little bit surprised that others were laying back, and I don't want to read too much into justices saying nothing, but I would say, I mentioned that McCullough and Russell are the 2 most conservative. If you think of the most active judge on the left, that would be Thomas Mann, followed by Fulton. Fulton interjected a question that was an attempt. It sounded like you could interpret it as an attempt to be helpful to the defendants. Didn't work out that way, but Mann didn't say anything. And I think that they are probably concerned at the rather brazen nature of the General Assembly's behavior here in the face of legal precedent of Virginia that says that we're going to strictly adhere to the requirements for passing constitutional amendments. And you could say a lot of things, but you can't really say that the General Assembly strictly adhered to Article 12, Section 1 requirements. So I hope that answers your question, Joe. I see Clark Palmer. How much does the fact that the public voted for district change weigh with the justices, and can that outweigh any possible legal issues? Excellent question, Clark. And it was actually Justice Russell's very first question of any justice in the argument. And I think he was just, everybody in the room knew the answer, but he asked, does the yes vote matter at all? He asked this of the counsel for Virginia, so the defendants. And Richard Hawkins, on behalf of the Solicitor General's Office of Virginia, conceded no, that the vote is irrelevant to the legal questions at issue. And, you know, putting my kind of commentator hat on, political commentator, not legal, I think the Democrats were probably counting on a much bigger margin and hoping that that would weigh heavily emotionally on the justices' minds as they considered these questions. But it was a very close vote, particularly when the yes side outspent the no side by 3 or 4 to 1. So even in persuasive effect, I don't think that vote is going to matter, Clark. Follow-up question from Joe Thomas. Attorney General Jones used the will of the voters in his statement last week. Yes, he did. And Joe asked, was the spending margin brought up or the turnout brought up as any sort of mandate? And no, the answer, no spending discussion or comments took place. The only discussion of this subject was the question and answer that I recited to you from Justice Russell and Richard Hawkins' answer to it, in which Attorney Hawkins acknowledged that the vote was irrelevant to the legal questions at issue. Brett Hall asked, why was the wording of the question not addressed? Great question. The answer is because that was addressed in the Tazewell case that was decided last week, that is coming up to the Virginia Supreme Court on appeal. The easy way to think of why the questions today occurred, they were what I would call the 2025 questions, the questions about first passage on Halloween of 2025. And the 2026 questions were decided by the Tazewell Circuit Court last week and are now coming up to the Virginia Supreme Court on appeal. I do not know that briefing schedule. I will post it as I learn it on my Twitter feed for folks. But the ballot question I actually put up on my Twitter feed also, so you can see it for yourself. It was ruled in violation of Virginia's plain English rule. Some states have a rule that, and when I say rule, I mean in law, a statute that requires fair and balanced language. Virginia doesn't have a fair and balanced statute, but we do have a plain English statute. And Judge Hurley ruled that the plain English statute was violated with the extreme misleading nature of the ballot language. So that was the ruling in the Circuit Court of Tazewell County, Brett, last week. That question, that is a statutory question, is coming up with the next appeal to the Virginia Supreme Court, along with the constitutional question of whether 90 days passed between second passage on January 16th and the submission of the question to the voters. And the issue there is early voting began on March 6th, which is less than 2 months after second passage, obviously not 90 days. But the other side will argue, well, April 21st was more than 90 days after second passage, and so that's what should count. So you'll be seeing that one come up. But that case will be mooted, and we will never hear it argued if the Supreme Court invalidates the referendum on either of the two constitutional questions from 2025 that were argued today, or on the statutory question that was argued today. I think the statutory question is very unlikely to be utilized to negate the referendum. But it is possible. Again, we didn't hear from 5 justices on that particular question. Justice Fulton weighed in on a different issue. So we'll see how that goes. And Clark asked how long before they would typically respond to what they heard today. So this is the fastest I've ever seen this court move. There was briefing. So the referendum took place last Tuesday, and you'll recall in January and February, there was litigation on these questions in the circuit court, and they came up to the Virginia Supreme Court, and the Supreme Court held them and said, we're not going to consider these until after the vote. And that was not because they were ducking. That was based on over 110 years of precedent in Virginia law that says the vote is part of the legislative process. The direct analogy is the governor signing a bill. I'm looking at suing on the assault weapons ban that's been moving through the Virginia General Assembly, but that is on Governor Spanberger's desk. And I can't sue until she either signs it or allows it to become law, because she might veto it. And until that legislative process is over, a court will not hear my question, meaning will not entertain a lawsuit on that. So that's why they held the case, but they did set it up for contingent briefing. If the yes side won, they did. Briefs came in last Thursday, only 2 days after the referendum. An oral argument obviously was held this morning. They know the need for speed. They understand there are elections this year and that everybody needs to know what the maps are, whatever they may end up being. And the sooner the better. I would, predictions are dangerous, but I would predict, Clark, that you're going to see a ruling in May, and I wouldn't be surprised to see one by mid-May nullifying the referendum. If I had to bet today, I would expect the Virginia Supreme Court to throw out the referendum because the process so brazenly didn't qualify with the requirements of the Virginia state constitution. Not seeing any more questions and not getting any directions from Melody. I'm gonna
Ken, just check a message I just sent you.
We are watching a virtual press conference from former Attorney General Ken Cuccinelli.
Because we're also dual broadcasting this on Twitter from the election
Cuccinelli saying that he has never seen the court move so fast. The oral arguments that we heard this morning in Virginia State Supreme Court moving very fast to take up this case, and hearing arguments about the 2025 questions, and we'll recap that here in a second.
Let's see. So those of you on press, you can stay on here if you want. I am done here, but I'm going to use the Zoom channel to essentially redo this press conference to explain the case to folks on Twitter. Melody, do I understand that folks on Twitter only just now are starting to hear us?
All right, so we're going to dump out of that press conference here and go back and kill the audio here. So you just heard former Attorney General Ken Cuccinelli tell us that not only has the Virginia State Supreme Court acted the fastest he has ever seen it act in any case in this gerrymander here, he expects a decision by mid-May, and he fully expects the Virginia Supreme Court to overturn the gerrymander election we just had less than a week ago. So that is big news. Cuccinelli broke it down into say that Yep. Make sure I'm still here. I'm still here. Okay, so we're looking at the results here. I love this map. This is the map from last Tuesday. You see the purple vote is the no vote, the orange vote being the yes vote, highly concentrated vote in Northern Virginia, and then down in Chesapeake, Hampton Roads, and of course the Richmond metro area, Richmond City. Henrico and Chesterfield counties there, bringing in, this is Albemarle County here in the Charlottesville area. You have the cities, you have Stanton, Harrisonburg, Winchester, Roanoke here, all going for the yes vote. So, but at any rate, you see the vast difference between the state here. You have on the referendum. But going back to what Cuccinelli was saying, the arguments that we heard this morning in Scova were on the 2025 questions, and essentially what you had is you have the no vote, the conservatives, Republicans in this case, arguing, saying, listen, you waited until over 1 million people had already voted voted early during the 45-day early voting period for the November election, the November 4th general election. A 45-day period that Democrats pushed for back in 2020, a 45-day period that they say would allow more people a voice, give more people access to the polls, more people to be able to participate in the electoral process. They argued for that, giving Virginia the largest early voting window of any other state in the union. And today, we heard the people defending the gerrymander, the Democrats, say, well, yeah, but election day is still election day, and it doesn't really matter what we introduce after early voting begins. Doesn't really matter if you know what you're voting on. Doesn't really matter if you knew what we were going to do, whether or not we were going to hold a referendum or not on redistricting. If we introduce it later, which they did on Halloween, well into the voting period after over 1 million people had already voted, that doesn't matter because election day is still election day. So one has to wonder, can you have it both ways, right? Can you push for 45-day early voting period and then say, well, yeah, but the votes that cast, it doesn't really matter if you knew what you're voting for. It doesn't matter. Election day is still election day. And so now they're holding election day to account, whereas before they're wanting 45-day early voting period, which every voting registrar in Virginia who has to hold these elections, who has to actually work these elections, bring in staff to man their office, to have people walk in during the day, and then during the last 2 weekends leading up to election day to open early in-person voting locations, sometimes especially Northern Virginia, multiple early in-person voting locations. It's all very costly. And you can ask any voter registrar across the state that since the Democrats have put this 45-day early voting period in place, costs for elections have skyrocketed across the state. And taxpayers, you and me, end up footing the bill for this. And now for the yes vote, Attorney Jay Jones and his cohort that came in to argue this today, to say that those votes, don't really, it's not a big deal. It's not a big deal. It doesn't really matter if they know what they're voting on. Election day is still election day, and that's all that counts. And that was their argument this morning. And of course, you had the no vote saying, hey, listen, and they cited a Democrat who was one of the plaintiffs in this case, saying, hey, listen, if I knew this redistricting was going to be a thing, I would have voted differently. And also, if I had known that it was my delegate that brought this redistricting thing forward to the General Assembly that was eventually passed, I might have voted against that delegate because he was on the ballot in November. And I actually voted for the Independent Redistricting Commission back in 2020, as did 66% of the registered voters who participated in that election. Well over the majority of voters voted in for the Independent Redistricting Committee. And so that was one of the plaintiffs that we heard from this morning. So as Cuccinelli, you heard Cuccinelli say that today's arguments before the Supreme Court took up the 2025 questions as to whether or not there was enough time between the Democrats' decision to hold a special election for the gerrymander. There was enough time with an intervening election in between, because you have to have two elections, an intervening election from the time that you make an announcement, you make it essentially pass the bill to hold a constitutional amendment, which they did in Halloween of 2025, again after early voting had already begun. And then you have to have a 90 days to go forward before a special election again once they pass it a second time. And so once they passed it a second time in January, there was fewer than 90 days before early voting for the April 21st, 2026 election started on March 6th. So there was not that 90-day required passage of time between the second vote in January, as soon as Spanberger took office and the General Assembly went into session. That wasn't even there, and that is a requirement under the Constitution as well. So we are waiting to hear on. So this morning focused a lot on the 2025 questions, and then there is another case coming up from Tazewell that will go straight to the state Supreme Court. We don't have the timing on that. We don't know when SCOVA will take that up, but it deals with the 2026 questions. As I was just talking about, was there enough time between the second passage of the referendum in January? When was that 90-day period enough before it went to voters before early voting started on March 6th? So, early voting is the issue here, is a key procedural issue. Did voters know exactly what they were voting on when they stepped into the polling place? And did they have enough time? And we're talking about back in 2025, November of 2025. Did voters know that the redistricting would be a thing? No, they didn't, because the Democrats in the General Assembly didn't make it a thing until Halloween, days before the general election. And so that is what we'll be hearing about from the outcome of this argument. Now, as Cuccinelli said, if the Supreme Court in mid-May overturns the referendum, as he expects them to do, then this will just overturn it. And the 2026 questions as to whether or not there was enough intervening time between early voting in March of this year and 26, the ballot question, we talked so much about the egregious text in the ballot question, the confusing restore fairness. We've talked so much about that, how it was intentionally worded to be confusing. That wasn't even talked about today at the Supreme Court of Virginia, because that is a 2026 issue. And that will be brought up in a second case to be heard by SCOVA at a later date. Again, we don't know the date, but the whole ballot referendum question itself and the intervening time between a second election, those are all things that SCOVA will hear if they do not ultimately overturn the referendum on today's oral arguments based on the 2025 questions. Folks, we've been going on this for over 2 hours now. Thank you so much for joining me here on Virginia Insider. There is a lot happening with this case. I can't thank you enough. Again, I will tell you that back on March 1st, our channel had 500 subscribers. And today we're well over 13,000, because you believe in what we're doing. You think that the information that we share, the message that we're broadcasting out to Virginia and to the world is important enough to support, and you want to be a part of this community. Thank you so very much for your continued support, all your chats, all your likes, all your comments, all your super chats. Please like and share this video. Please tell a friend about our channel. Please go to if you're on X, follow us there, X at Virginia Insider. And we will continue to stay atop of this story and bring you the latest news and information about this gerrymander and everything else in Virginia, so you have the news and information you need to take back your Commonwealth and to connect with your community. Have a great day.